I'm Hannah Shea, for those of you who have not met me, but you have received many emails from me, I'm sure, in the past. I see we do have some new faces here, which is really nice. But I work with our 15 practice and industry groups, privacy and data technology being one of those groups. And how we typically structure meetings with this group, each region hosts its own meeting throughout the year. So we had Americas toward the end of last year. This is focused on Asia updates, and then we'll have an EMEA one in April. And of course, then we always try to do one where it's sort of everybody, or it's topically based for everyone to discuss. So everybody sort of gets a chance to share their updates with others in the network, and also meet others in the network, not just in their regions, but in other regions as well. We do record this meeting, so it will be available on our website after, for anybody who may have missed, or if we have folks in Europe who are interested in the Asia updates, they can listen to it since they are probably all in bed right now. And just so you know, the autopilot that you see, that is my artificial intelligence note-taking service, appropriate to mention, this being a privacy and data protection group meeting. But that joins me in all of these meetings, unless of course somebody asks to turn it off. So if for whatever reason you want it turned off, just let me know. But it really just transcribes the meeting notes so that it helps me put together some quick takeaways that I send to you all afterward. And with that, I am just going to do a very quick introduction of ESCO. ESCO has recently joined us last year as the co-chair for this group, for the Privacy and Data Protection Group from the Asia Pacific region. So ESCO will be the one running this meeting today, and now I'll hand it over to ESCO.
Thanks, Hannah, and hello, everybody. Good morning. I think for almost everyone here, other than you, Hannah, of course, good evening to you. So let's go ahead and get started. I think I'm gonna start by just giving a quick overview of the planning for the meeting. Hannah suggested, and I think this is a really good idea, since we have some new faces today, maybe we can just run through really quickly and everyone can kind of introduce themselves, take 60 seconds to tell about yourself, your work, and your firm, where you're from. And then after that, we can move into some updates. I know that there are a few updates, or at least a couple updates related to artificial intelligence regulations that are likely going to be relevant to our topic, which is data protection. So we'll cover those. And then we have Yatin, who will provide a presentation at the end of this meeting on India's new regulations for data protection. So let's go ahead and I can go ahead and get started first. As Hannah said, my name's Esco. I'm an American attorney. I'm working right now in Ho Chi Minh City, Vietnam. And data protection is a pretty significant portion of my practice, although I also do a few other things related to foreign direct investment. Let's see, who wants to go? Yatin, do you want to go next?
Yeah, hi. I am Yatan Naran. I'm working in Vesh Associates at its Mumbai office in India. In India, the data protection is now started, and it is a very important part of the deals because of the new law that has come up. In my organization, I deal with the data protection, and I also look into the mergers acquisitions aspect in the firm.
Thanks, Yatin. I think we can I'll move. I don't know actually if everyone in Zoom has the same layout for individuals, but I'll move right to left. So Irene, maybe you can go next.
Sure, let's go. Hi everyone. Irene from Shendel Mall, Malaysian full service law firm. I do both tax and data protection, and there's increasingly some convergence between the two, and I'll allude to that later.
Thank you, Irene. Kanako, would you like to go next?
Sorry, just mute. I'm Kanako Inoguchi at the CTU Partners in Japan. And I I have been handling so many data privacy issues, including EU issues, since I formerly belonged to the global law firm and moved to this CTU, our partners. And I recently found that the Japanese government is leaning to GDPR or EU regulation, including generative AI regulation. I believe. Nice to meet you.
Yeah, pleasure to meet you too, and thank you for sharing that. Actually, later, if you would like to elaborate on that and we have some time, that would be great. I'd love to hear more about that. Paul, would you like to go next?
Sure. So Paul Cullenbach, I'm a partner at Minter Ellison, which is Australia's largest integrated law firm. My practice is in technology, privacy, and data. And it's sort of the hot area of legal practice at the moment. We are on the cusp of the biggest privacy reforms in this country in around about 2 decades. So we can expect lots of regulatory action over the next year as the government forms up the legislation.
Thanks, Paul, and thanks for joining us. That to me actually sounds like another pretty interesting topic. If we have time, I'd love to hear about what you anticipate you'll see over the next year in terms of this evolving regulations. Susie, would you like to go next?
Yeah, hi, I'm Susie McMillan. I'm a senior associate at Minter Ellison Rudd Watts in New Zealand. I'm in the Auckland office here, and I lead our privacy and data protection practice along with my other colleagues. I work, like Paul, in the technology, privacy, and also consumer law space here.
Great, thanks, Susie. Akira, would you like to go?
Hi, my name is Akira. I'm with Miss Inakuchi's the Saints firm at City U in Tokyo. My clients are basically tech clients, and they are doing AI. So the privacy law issue always comes up, and I always ask Miss Inakuchi for help, but I just joined this meeting to catch up with what's happening in the surrounding areas of Japan because it's always an issue.
Yeah, definitely. I agree with you. I think that's one of the biggest strengths for World Law Group is it really does give a great forum to kind of get a good feel for what's going on in other regions that I think at least most of our practices, we are working across borders in a lot of cases. And so I think that that's really a great strength here. Ted, would you like to go next?
Sure, happy to. Good to see everyone. I'm Ted Augustinos. I co-lead the privacy and cybersecurity practice at Lock Lord in the US. Happy to join you all. And I also serve as co-chair for this group with ESCO, but I'm responsible for the Americas. So good to see you all.
Thanks, Ted, and thanks for joining us. An evening for you as well. Nick, how's it going? Could you introduce yourself?
Hi everyone, nice to meet you again, Esco. So I'm a senior associate with Wong Partnership in Singapore, and I'm with the IP Technology and Data Group in Wong Partnership. So we deal with IP, technology, media, telco, and cyber data matters, and I advise across both commercial and government sectors. Nice to meet everyone.
Thank you, Nick. Puspa, would you like to introduce yourself?
Yes, thank you, Esco. Hi, everyone. I'm Puspa. I'm senior associate at Makarim and Tyra. I'm also a certified data protection officer in Indonesia. And happy to meet you all. And Indonesia has issued a data protection law in 2022, but full implementation will be achieved in 2 years. So the government gives time for 2 years for us to comply with all the provisions until 20 September 2024. We'll be happy to provide more updates on this later. Thank you.
Sounds to me as though you might have a bit of a busy year ahead of you then, with the regulations coming online. Probably quite a few people that will be needing assistance with that. And so hopefully Hopefully you'll be able to get some good experience that you can share with us about the client's issues and what you're seeing in trends in the market there. Rachit, would you like to go?
Hi, morning everyone, evening to my colleagues in other parts of the world. My name is Rachit Behr. I'm a partner with a firm called AZB and Partners. It is a substantial law firm within India. I lead the data privacy practice. Along with it, I do a lot of work in the tech space. And I think like Paul, who is looking forward to some data privacy reforms in the last 20 years, I think India is on the cusp of a huge privacy reform in like about forever, right? So this is a big moment as far as Indian legal landscape is concerned. There seems to be some kind of a perception that if you are GDPR compliant, then you are almost there. It's not true. I'm sure Yatin is going to talk about some of that as we go along. But India has a big jurisdiction, and if you're a data privacy lawyer, India is the place to be for now.
Great, thank you for that. And yeah, I think we're all quite interested to hear the updates on the regulations coming out of India and get, especially I think that comparative perspective of India versus GDPR would be a bit of a, be very beneficial to a lot of us, since I do think a lot of us are maybe outside of our own jurisdictions, maybe most familiar with GDPR as kind of the standard for data protection regulations. Ken, would you like to share?
Sure. Hello everyone. This is Kent. I'm working for Zhongren in our Guangzhou office, which is in the south, very close to Hong Kong. Actually, I'm traveling in Hong Kong today, so probably I will turn off my video when I finish this. So I used to work as a corporate commercial lawyer, so mainly dealing with foreign direct investment, so helping foreign clients to make to do investment into China, and along the line, you know, with the newly issued legislation in personal data protection. Then a lot of our clients, you know, approaching us to, you know, to help them to understand, you know, how to move either the users or the employees or the, you know, the suppliers, you know, personal data out of China. So that's how I get involved in data privacy laws. And the business for the last years were actually quite good because of the you know, newly issued legislation. So basically, China has started to somehow copy GDPR in a quite strict way. But recent years, like you know, since 2023, because the economy is not you know, very good, and which actually you know, causes a lot of difficulties for the business. So China now has tried to relax a little bit, you know, in the practice on moving data out of China. I hope that we got, you know, more opportunities to share this with our colleagues. Thank you.
Thanks, Ken. Actually, Tim, that's a pretty perfect segue into the next segment, which I think is regional updates on new regulations or any kind of, I suppose, anything interesting that's going on in relation to data protection. You just mentioned that China, you believe, will be loosening the regulations on sending data out. I don't know if you wanted to elaborate more on what you anticipate or if that's a possibility at this time. If so, please, that would be wonderful if you could share that with us.
Okay. So previously there are like three ways to move data out of China. So one is to do the security check, which is the strict, which is you know, very strict way. Then and for that purpose, you know, the government, the the reporting and should be made to the government, and also the government authority will do the assessment and everything. Then secondly, then there is a way to do that with so-called self certification. So basically, the company in China would do that by themselves. Certainly, when there is only a few data transfer, then the company in China can sign a standard contract, which the template is issued by the government as a guidelines. So that's three ways, but and at the moment, the government is trying to relax the standards and the specification and for the first two, like the security check and also the self assessment certification part. By lowering the amount of the data involved, and also by streamlining the process. So that's basically the situation.
Thanks. Do you anticipate that this will come in the form of new regulations or guiding regulations, like an actual overhaul and amendment to change what the current regulations are, or just guide them?
This will be implemented with a new regulation, I would say.
Okay, that's quite interesting. The reason why I ask is here in Vietnam, we also last year provided or promulgated a new data protection law that is it's drafted broadly, doesn't have particularly good guidelines or hardly any guidelines at this point. And as such, it's also extremely restrictive for transfer. The one thing that does seem different here is for outbound transfer from Vietnam, the process under the new regulations, it's not an approval. So we don't need an approval, but there are reporting requirements that are quite difficult to put into practice for a lot of our clients and a lot of our companies inside Vietnam. So that's why I was kind of curious how China was addressing this, and because I think potentially we'll see similar style of maybe amendment or supplementation to the current laws or the current regulations in order to accommodate outbound transfer. Anyway, thank you. Yeah, thank you very much for that update. If you have any more you'd like to share, please do.
Okay,
Otherwise,
so I think China has a lot of similarity with probably Vietnam and some other Southeast Asia countries. Although there are like legislations, but in practice, it actually subject to a lot of like actual enforcement by the authority. And in China, the situation now is that because of all of the legislations is quite new, then actually a lot of local authorities, when they deal with this, they are quite hesitating. They don't want to make a bold move, or they don't want to make a mistake, things like that. And the situation also makes the practice very complicated.
I agree. I think we are seeing a very similar thing here in Vietnam. Anyway, thank you for that update. That I think was quite helpful and quite informative for the group, and we're looking forward to hearing, I guess, what has happened and what has transpired on the next meeting. Let's go ahead and move. I know that there's a couple other people in the group that did have updates related to regulations in their jurisdictions. Actually, I think Puspa, you had an update prepared. Would you like to share it?
Yeah, sure. So Indonesia didn't have adequate personal data protection regulations until the end of 2022, where the law is mostly adopted from the GDPR. But as I mentioned, full implementation will be expected by 20 September 2024. Currently, the government is drafting the implementing regulation for the technical provisions of the law. So for this time, the company working on to fully comply with the law. So the issue that comes up for international cross-border clients about the cross-border data transfer. So before the issuance of the PDP law, the cross-border data transfer in Indonesia requires consent from the data subjects to transfer. All must be consent, and also must be reported like annually or quarterly to the Ministry of Communications and Informatics, which is quite not practical because we do transfer data every day, every month. It's with a big data, and it's not practical to report to the Ministry of Communications. Now the PDP law adopts the concept from the GDPR that for the cross-border transfer, they have one adequacy requirement. So controllers must ensure the recipient party country has a level of personal data protection equal or higher than the provisions in the PDP law. So the Data Protection Agency in Indonesia will prepare a list of countries and international organizations to be prepared to confirm which country has an adequate law compared to Indonesia. If it is not achieved, the adequacy requirement, it will be under binding PDP measures. So controllers must ensure there is an adequate and binding PDP, which may take in several documents forms, such as agreements between the sending and recipient countries, standard PDP contractual clauses, or company regulations. The draft implementing regulations provides that the forms of these PDP measures must be approved also with the PDP agency in Indonesia. And if adequacy and binding PDP measure cannot be achieved, then the controller must obtain consent from the data subjects. And the second issue is about the minor age. So in Indonesia, there is no quite standard minor age in each regulation. For example, in the child regulation, the minor age is below 16, and in the marriage law, it's below 18. Because Indonesia is a civil law country, it adopts the Indonesian Civil Code, which is the legal age is 20 years old to engage in a transaction, which is too late to be applied in the like a privacy policy and all. So that becomes an issue if we have to apply 21 years old as a minor age in for example like e-commerce platform or else. And the privacy policy or terms of services must be translated into Indonesian language. And lastly, the acquisition of a company must also be notified to the owner of the data if it engages the transfer of data. I think that's quite a material points in the PDP law.
Yeah, thank you for that. That's quite informative. One question that I had based on your update there is about I guess the enforcement or the actual procedures with that come out of this. You mentioned that you need to receive approval for adequacy. Is that easy to get, or is that proven challenging? Have you seen any examples of this yet? I know it's quite new.
Not yet. Actually, it's supposed to be prepared by the agency, but the agency itself has not been established yet. So that agency should be an independent agency outside from the ministry. So they will prepare or update like a list of countries that if the recipient country is listed in this list, then you can transfer the data without the consent. But back to the privacy policy, you should have noticed that the customer data or something like that may necessary to be transferred to other countries, something like that, without an explicit consent on that.
Right, that makes sense, and that also sounds a bit similar to what we see in Vietnam, where I suppose the enforcement or the regulatory agency did exist at the time the regulation was promulgated, but it most certainly wasn't prepared to handle the inflow of approvals and submissions that go along with the new regulation. So yeah, that'll also be interesting for us, I think, in this group to watch and see how that transpires and works itself out in Indonesia. Okay, so and I think there's a couple other updates that we have here. I probably the next I'd like to move to Akira from Japan. You had an update in relation to the AI regulations there, which I think could be a bit interesting for us to hear about.
Was it me? I think it was Hanako-san, or
Uh,
let's see.
Sure. We can also we can move past if there's not if there's not an update from Japan, that's okay.
Well,
Uh,
the Japanese government is trying to they drafted a guideline for using AI, and it covers also privacy law and also
okay.
IP law.
Hmm.
But it's still a guideline. So I looked at it, and I think still needs more substance to be able to actually use in a legal context. But I guess I will need to keep everyone updated on that.
Sure. And we're all very excited. I think that area of law in particular, we're kind of seeing a kind of common trend where it's a lot of that. I think regulators don't necessarily know what they want to do or what they need to do. And so they're kind of learning as they go too. It's just developed so quickly. But yeah, we'd love to hear more updates as they become available. Let's see. Nick, I think you also maybe would have had an update related to AI regulations in Singapore.
Just a couple of updates, not particularly only restricted to artificial intelligence. But I think in the past 6 months, the Singapore regulators were trying to consult the public and several industries on how to interpret the current comprehensive data protection laws to apply to new technologies, as well as to enhance protection of minors. So these are the two areas that the government is closely looking at, and we expect developments to roll out in 2024 relating to AI in recommendation systems. That's one. And two, enhancement of um, handling of children's data or minors' data. So in the past 6 months, the regulators have been consulting the public on these two areas. For example, in terms of AI recommendation systems, the regulator was looking at applying the current legislative framework across the entire AI lifecycle. So for example, in development and testing and monitoring, um, how do principles like data minimization and anonymization apply? In terms of deployment in the B2C context, the government was toying with the idea of encouraging the industry to adopt model cards, system cards for notification to users. Um, and how might that align with accountability? So they were studying that. And finally, in terms of AI procurement in the B2B context, I think the regulator was researching how data intermediaries or processors can be further encouraged in a legislative sense to provide support to data controllers to help controllers meet transparency obligations in terms of the processing of the technology in AI. Of course, then moving on to the minor protection front, this is not AI specific, but the government was researching how to provide further guidance to the industry on handling minors' data in a way that is updated with current technologies. One of the funny problem that the regulator was studying is how to minimize data collection of minors, because you need to protect minors, you first need to collect data from them to know that they are minors to protect them. So I think the regulator is closely studying how to strike the right balance. Yeah.
Thanks, Nick. That's very helpful and I think very interesting in general for all of us. I think that this is kind of a reoccurring theme that I'm hearing through a lot of jurisdictions is this consideration of protection for minors in relation to AI or just in general for data protection. I know in Vietnam it's been kind of a substantial issue for a lot of our clients. because of the additional actual things that they need to build into their platforms, etc., in order to handle the requirements of reporting, etc., and the additional protections that are required under the regulations for collection, processing of data belonging to minors. Let's see. So I think we have a few other jurisdictions that are here. I don't have any scheduled updates necessarily, but I think Irene, if you have anything you'd like to share from Malaysia.
Sure. Thanks, Esco. So we've had the Data Protection Act in force for the last 10 years. It had never been updated. Last year, the ministry indicated that the draft bill is in the works, and it looks likely that there may be increased fines and the requirement to have a compulsory data protection officer. At the moment, it's not mandatory to have a data protection officer in Malaysia. And also perhaps the legislative amendment may include having to mandatory data breach notification. So as you can see, our current data protection legislation is quite basic. It was, I think, premised on the old UK Data Protection Act in the 70s or 80s. So there's a lot of updating that needs to be done. The ministry has also indicated early this year that they will issue 7 guidelines, one of which is so that's the notification of data breach guidelines, data protection officers guidelines. So I think that's likely to be passed as a requirement under the new amendments. And also there'll be 5 other guidelines: data portability, cross-border data transfers, data protection impact assessment, privacy by design, and profiling and automated decision-making guidelines. So those are in the works. And unfortunately, we don't have any visibility on what they will be, apart from the fact that it looks like data portability is probably something that's possible now pursuant to the guidelines. I don't know whether we have time for a quick case law update, because we've actually been handling a tax case, which also is a data protection case. It's really at the High Court. So this case arose because the tax authority, which we call the IRB in Malaysia, requests for the entire database of personal data from our clients' loyalty program. So it's all the entire database. So some of which, I think all of which is personal data. So it's personal data of individuals as in Malaysia as well as foreign individuals. So the case is Genting Malaysia Berhad against the Director General of Inland Revenue as well as the Personal Data Protection Commissioner. So Genting has resisted and said, we can't give you this data, although the IRB was exercising or purporting to exercise their powers under the Income Tax Act to require any person to give information for tax purposes. So obviously this information doesn't relate to Genting per se, it relates to their customers who are individuals. So Genting didn't want to give the data, and we got involved and filed the application in court. But prior to that, the tax authorities also got the view of the Personal Data Protection Commissioner, and the Deputy Personal Data Protection Commissioner actually said it is okay for you to disclose the data, which is quite shocking for enforcement authority to say. So was telling that you may disclose the data because there's an exemption where you can disclose the data if of an individual if it's required or authorized by law. So the question of whether it's actually authorized or required by law is actually moot. But the Data Protection Commission does say was okay. At the High Court, the court agreed that this is a breach. If they release the data, it would constitute a breach of the Personal Data Protection Act, and the PDPA, being a later legislation and more specific legislation than Income Tax Act, prevails over and overrides the tax provisions, which requires disclosure of information. The court will say you can't use the Income Tax Act as for fishing expedition because these individuals have not been named or identified. It's basically the tax authorities asking for the entire database on the basis that they want to enlarge their database, increase tax collection. So successful at the High Court, then the authorities appeal to the Court of Appeal. So the case is pending decision before the Court of Appeal. After the Data Protection Commissioners filed their appeal, they dropped the appeal, but the tax authorities have gone on to pursue the appeal. So it's an interesting case. Our constitution actually has Article 5, which protects privacy and is been recognized by the highest court that includes personal data. So that's the long and short for now, but watch this space.
Yeah, that really is. Thanks for that update. That really is a very fascinating case. Especially, I think anytime you can see that two laws are like coming to conflict with each other, that can be pretty interesting. But I think that happens, or at least I've seen that happen quite regularly with data protection regulations. I think this is another kind of thing that often gets smoothed out as the regulations evolve and develop. We can maybe see that in certain jurisdictions that have longer standing personal data regulations. But yeah, that's quite a very interesting case that you have there, and I'd love to hear the outcome of the appeal. All right, Paul, you would like to go, please share what you can from Australia, and we'd love to hear about prospectively what you anticipate will be coming down the pipeline in terms of regulation. Paul, I think you're still on mute if you...
I am, and now I'm not.
Okay.
Hi,
Great.
everyone. So I mentioned before that we're on the cusp of very significant legislative reform. So this played out last year. There was a Attorney General's report that recommended, it had 116 recommendations for changes to aspects of the Privacy Act. The government responded in September. So of those 116, it accepted 38, which means that 38 will be the subject of legislation with some limited consultation for that legislation. 68 were accepted in principle, which means that it plans to legislate, but following a further consultation and impact analysis process. And then 10 were just noted, which means that no further or no immediate further action will be taken. So just in terms of, obviously I'm not going to go through 106 of 116, but the themes, some of the themes flow from some of the very large data breaches that we've had in the last couple of years. We had the Optus data breach, we had the Medibank data breach. So there's been a lot of public focus on privacy and uplifting privacy protections. If you're looking for an overarching theme, it's probably one that we've heard on this call already, which is really moving to more of a GDPR standard for privacy protection. So sort of breaking it down, there's sort of, I guess, 5 things that the government's looking at. One is uplifting what is quite an old piece of legislation now into the digital age. So, for example, specifying that certain types of information are personal information, such as IP addresses. So there's sort of grey areas under our law at the moment as to whether certain things are or are not personal information. Broadly uplifting protections. So one of the things the government said it's going to do is more closely specify at a technical and organisational level what organisations need to do to satisfy the security obligation under Privacy Principle 11. And they've also agreed to reform the data breach scheme in a couple of ways. One, they've agreed in principle to move our timeframes closer to the GDPR. So at the moment, the organisations have 30 days to investigate a data breach. We're moving towards 72 hours in Australia. So as if there are not enough pressures on organisations, and of course, this is not the only piece of legislation that there's notification under. If you're a financial institution, you've got APRA. We've also got security of critical infrastructure legislation. We've got obligations under Corps Act if you're a financial services licensee. So some organisations have 5 or 6 notifications they need to make to different regulators. But it looks like the screws are only going to tighten and not loosen. And that's been one of the criticisms, that let's have some sort of clearinghouse so that we're not running around spending all our time trying to notify 5 different regulators. There's going to be an increase in changing some of the definitions and concepts to clarify them, things like consent. What does consent mean? One thing that we're looking forward to is at the moment, there's no white list of countries that are considered to have substantially similar privacy laws. So the adequacy decision under the GDPR. And I think the government has finally agreed to include a mechanism so that we can have a white list so that we understand what jurisdictions are okay to transfer data to. Increasing control and transparency of individuals. So this is a huge one. The government's agreed in principle to implement a direct right of action. So at the moment, if privacy is breached, you complain to the Privacy Commissioner. There's no direct right of action against the organisation that's breached. So they're looking not only at a direct right of action, but also potentially a statutory tort for serious invasions of privacy. But there's going to be a lot of consultation on that, and the media industry are obviously up in arms about that because that will have significant impact on what they can and can't do in terms of potentially reporting. The last thing I'll mention is enforcement. So as a reaction to the large data breaches that I mentioned, there was actually a change in law last November to increase the penalties under the Privacy Act to up to $50 million. So that's already in law. The issue with that is that at the moment, that penalty only relates to what are called serious invasions of privacy, which is a very high bar. What the regulator's very excited about here is potentially a graduated set of penalties, including sort of fines that they can levy against organisations for lesser breaches of privacy. But again, it's a bit of a lightning rod for, someone said it's, the thing to be as a privacy lawyer at the moment. This is the number one thing that organisations are concerned about, cyber breaches, but also enforcement and compliance and risk compliance. So with a graduated set of penalties, it makes it even more important for companies and boards to look at these sorts of issues. So yeah, very exciting to be a privacy lawyer at the moment in this country, and I think we've got a busy time ahead of us in the next couple of years.
Thank you, Paul. Yeah, definitely, I agree with you entirely. Privacy attorneys, at least, is certainly the interesting thing to be right now.
Yeah,
that's most certainly I agree with you on that. We're excited to hear, I guess, what how this progresses and what I guess hear quite a bit about Australia's implementation of these new regulations once they're in their final form. I want to leave time for Yatin's presentation, but I did want to check with you, Susie. Do you have any, if you wanted to share anything about New Zealand?
Yeah, just very briefly, no major changes on the New Zealand front, but our Privacy Commissioner is introducing a biometrics code of practice this year. They're seeking consultation on a draft code, hopefully in the next month or so. So essentially, the Commissioner is concerned about the use of biometric information and is proposing to introduce a code of practice, which would essentially impose more restrictions around the use of that information in addition to Privacy Act protection. So it will amend the privacy laws, so to speak, in relation to biometric information. They're specifically worried about, proportionality, so whether it's actually necessary to collect that information, around transparency of use of that information, and then they are looking to impose certain restrictions. So there will be types of things that you can't use that information for. And that will be a new regulation which will be implemented in New Zealand, and that will also sit alongside the Commissioner's guidance around the use of generative AI. And so they put out guidance last year on their expectations about using AI in a privacy context. So it will be interesting to see those two pieces kind of flow into companies' use this year. There'll be some heavy compliance steps that need to be taken if you are using AI and or collecting biometric information. So there'll be some additional work there for organisations operating in New Zealand.
Great, thank you. That's very helpful. I think the concept actually just in general for biometric data being protected separately, at least in Vietnam, we haven't seen that. Although I would love to hear a bit more from different jurisdictions about how that's handled. Because to me, I definitely agree. It's something different, and I think it does warrant potentially a different level of protection. So thank you for that update. I think that covers all of the jurisdictions that we have today outside of India, and which I think Yatin is about to go ahead and give us the highlights. I know there's substantial updates coming from India, and so Yatin, I would like to turn it over to you to go ahead and move and share your presentation with us.
Sure, sure. Yeah, is my presentation visible?
We can see it, yes.
All right. So hi everyone. So this is the Digital Personal Data Protection Act 2023. This is the new act which has been framed by the Indian Parliament in August 2023. It draws upon concepts which are akin to those in GDPR. Having said that, the principles are same, but still there are differences which I'll be covering towards the end of the presentation. One thing it has to be noted that though the act has been published in the official gazette, it is yet not enforced. The government will come with a separate date when the act will be enforced. We are expecting anytime the rules under these regulations for public consultations. And around April, May, after our general elections, we may see the enforcement of the rules in the act. Once this act comes into the play, it will replace the existing SPDI rules of 2011, which deals with 8 categories of protection of sensitive personal data. Also now in 2017, the Supreme Court of India, which is the apex court of India, it affirmed the right of privacy as a fundamental rights for the Indian citizens. And therefore, the whole process of drafting a comprehensive regulation around that, it started. There were various versions of these act. The final one got an assent from the president in August 2023. Now, this act you would see is to which this act is applicable. It is applicable to the processing of digital personal data within the territory of India and processing of digital personal data outside the territory of India in connection with any activity relating to offering goods and services to data principals within the territory of India. This act is applicable to a data in digitized form or a data which is collected in non-digitized form but subsequently converted into digitized form. It is not applicable to non-digitized data. This act is not applicable when the person is using the data for a personal use or when the data is in public domain, which has been made public by the person who is or the data principal or anyone who's authorized under the law to publish such information. The concepts remain more or less the same as under the GDPR. The data processor is the person who processes personal data on behalf of data fiduciary. We are referring data principal is the person who owns the personal data. And as data controller under GDPR, it is known as data fiduciary under DPDP Act, who determines the purpose and means of processing the personal data. The child under Indian law is any individual who has not completed the age of 18 years. Now, there are 2 grounds for processing data under the DPDP Act. One is the consent and other legitimate uses. And we'll deal one by one. And legitimate uses are specified number, and it's not a general list of information. So the DPDP Act says the consent which has to be obtained has to be specific, unconditional, unambiguous, free, and informed. It should be in a manner which forms an agreement between the data principal and the data fiduciary. It should be very limited and very specific for what you are asking. Any part of the consent which is in infringement of the act or the rules of the DPDP Act, it will be invalid to that extent. We are required to provide the consent in English and as well as other languages, 26 languages which are there in the Indian Constitution. There has to be a mechanism for withdrawal of consent. Also, in case there is a dispute between the data principal and data fiduciary as to whether a consent was taken or not, the burden of proof lies on the data fiduciary. Now, the legitimate uses is the other way where we can process the data without obtaining the consent. Now, these are very specific and limited, and it is not generally, and it is different from the legitimate interest under the GDPR. One of the grounds is voluntarily provision of data. So where a person has, or a data person has himself given or herself has given a personal data to the data fiduciary for specified purpose, and it has not indicated that it does not want the consent data fiduciary not to use that personal data. Data fiduciary can process the consent. For the state or their instrumentalities, the data can be processed for providing benefit and subsidiary by the state and instrumentalities for any function under any law for the time being in force. The personal data can be processed for fulfilling obligations under the law or the compliance of court orders. The data can be processed during medical emergencies, spread of epidemics and disasters for providing relief work. This is very interesting in India for the employment purposes, for provision of employment as well. You can process the data without obtaining the consent of the employees, as well as for safeguarding the interest of the employer and for causing any loss or liability to the employer. The employer can process the data of employees without any consent from the employees. The DPDP Act mandates that a notice has to generally precede or accompanies the request for consent, and it says the notice must state what is the personal data, what is the purpose of processing, the manner in which data principal may exercise his or rights under the Act, and the manner in which a complaint can be made under the Act. There will be various other things which can be, which has to be there in the notice, which I think will be more clarified when we receive the draft rules. The DPDP Act also says where the consent of the data principal has been obtained prior to the commencement of the DPDP Act, then the data fiduciary, after the DPDP Act comes into force, should send a notice to all the data principals, stating them all about their rights and what all data is with the data fiduciary and how they have processed and to whom they have shared. Until the data fiduciary withdraw their consents, the data principal withdraws the consent, the data fiduciary may continue to process the personal data. So under the DPDP Act, the data fiduciary is the main person to look after the protection of the data, of the personal data. The DPDP Act mandates that the data fiduciary will appoint the data processor only through a valid contract and shall ensure that the data processor has certain and essential safeguards. Under the DPDP Act, the prime responsibility is of the data fiduciary. It does not directly lay any obligation on the data processor. So if there's a breach, the board or the authorities will come against the data fiduciary. Therefore, data fiduciary also has an additional obligation to ensure that the personal data in their records are complete, accurate, and consistent with the personal data, especially when a decision has, if that data is used to make a decision that affects the data principal, or it is going to be disclosed to the another data fiduciary. Data fiduciary has to provide the mechanism where a data principal can request for erasure of the data, and if it is not required by law or for further processing, the data fiduciary is obligated to erase that data. Data fiduciary must ensure that the security safeguards are sufficiently there. Currently, the SPDI rules mandates ISO 27001 as a security standard. Let's see whether there are enhanced security standards mentioned in the rules, the draft rules which will be published. Under the DPDP Act, if there is a breach notification, the data fiduciary is obligated to notify both the board, which is a regulatory body under the DPDP, as well as the persons who were affected by the data breach. processing of children's personal data, as I mentioned, that 18 years of age is what it is there, and the Act mandates that there should be a verifiable method of taking a consent from the parents. Now, what amounts to a verifiable consent? There's a lot of discussion going on between the industry and the regulators. Let's see how we are waiting for the rules. What is the process in which what would constitute as a verifiable consent will form under. There is a special category of significant data fiduciary, which the government will come as to which categories will constitute a significant data fiduciaries. Maybe someone who processes a large amount of data or who processes certain sensitive personal data. So significant data fiduciaries have been obligated to appoint a data protection officer who shall be based in India. They also have to appoint independent auditor, and they have to carry out periodic audits and data protection impact assessment at the regular intervals. Rights of the data principals are very similar to what are there under the GDPR. They have a right to access information about personal data in a summary form, or to receive identities of all the data fiduciaries and data processors to whom the data has been shared, right to correct, complete, and update of the data, right to erasure of the data, right of grievance redressal, right to nominate, and right to withdrawal of consent. In DPDPA, there are certain obligations as well on the data principle. And there is a penalty for non-complying. There's a penalty of Indian rupees 10,000 if the data principle does not comply with. And to ensure, so they should not impersonate any other person and provide correct information. So those kind of obligations are on the data principles. Certain sections of the consent and data processing is not applicable in cases, when there are cases of detection, investigation, or prosecution of an offense, for enforcement of any right or claim, for if there is any court or tribunal order, then the data can be processed without any legitimate interest or obtaining consent. When there is a scheme of compromise or arrangement or mergers through a court process, then also you may not need the consent of the data principals. In fact, if there is a financial fraud committed by any person, then also the relevant sections are not drawn into picture. For research, archiving, or statistical purposes, the data can be exempted. The data processes, the sections are exempted. Government may come up with certain categories of data fiduciaries to whom these regulations do not apply, or these obligations do not apply, like startups and all. We'll have to await when the rules come. Like GDPR, in India also, there are penalties. However, the penalties are, in fixed numbers, like up to Indian rupees 250 crores, that is approximately 30 million US dollars, or 25 million US dollars. However, the board will determine what are the nature, gravity, and duration of the breach, the type of persons affected, repetitive nature of breach, the mitigation factors which the data fiduciary has taken on deciding the quantum of the penalty. And these penalties can be simultaneously. It is not a cap. It is simultaneously. They can be for, if there are 3 or 4 breaches, the board can give a simultaneous and add up the penalty. So there's no upper cap as such. Very quickly, the differences between the GDPR and DPDP. So, like as a cross-border transfers, we all know that GDPR provides that data may be transferred to third country in compliance with the adequacy agreements, standard contractual clauses, binding corporate rules. However, in India, the DPDP allows transfer of data to all the countries other than the prohibited countries. The list of the prohibited countries will be published by the Government of India in the rules, or as separate notifications. Other than that, to those countries, the data can be transferred across India. Of course, if there are any other guidelines in India, like Reserve Bank of India guidelines and sectors, which have stricter data transfer regulations, then that would prevail over the data protection guidelines. Under GDPR, there is a categories of personal data which relates to ethnic origin, political opinions, religious or philosophical beliefs. Under the DPDPA, all personal data are treated alike. and there's no difference has been made to the treatment. Under GDPR, the risky breaches have to be informed to the relevant supervisory authority and high-risk breaches to the data subjects. Under DPDPA, all breaches have to be reported to the board which is constituted under the DPDPA Act, and as well as to the data principal. In the extraterritorial application, you would have seen in GDPR, the monitoring of behavior of data subjects, as far as the behavior takes place within the European Union, is also covered. However, under DPDPA, if the monitoring of behavior of data is linked to provision of some goods and services, then only it is covered. Otherwise, if you are monitoring the behavior of data subjects in India without provision of goods and services, it is not covered under the DPDPA Act. GDPR does so under DPDPA Act. So if there is an Indian processor who processes the data of non-residents of India, and because of a contract with say a EU company, then also the DPDPA Act is not applicable to them. We have discussed about the penalty. The penalties are higher of 20 million or 4% of the firms worldwide under GDPR. We have discussed in India it is a 250 crores, $30 million or 25 million US. Under DPDPA, there's a penalty on data principal as well, whereas we have not seen any penalty on the data principal for providing wrong information. Anything which is there in the public domain is excluded under the DPDPA Act. However, GDPR includes scope processing of personal data that is publicly available also. I think these are the main differences which I wanted to highlight today in the part of the presentation, and it brings me to the end of the presentation. Thank you.
Thank you so much, Yatin. That was very, very informative, and I think there's a lot of information there that we could unpack further if we had a little bit more time. So, thank you for confining it to the amount of time that we have today. I'm sure that anyone here, you can confirm, but anyone here who has further questions on this should reach out to you, and you can probably provide a lot more detail than we had time for today. So, thank you very much for that. We're a couple minutes over. Oh yeah, go ahead.
Sorry, I just want to ask whether the slides will be made available. Maybe I missed it if you already said.
Yeah, Ted, I'll post them with the recording on the website.
That would be great. That was very helpful. Thanks very much.
Yeah, excellent. Okay, so with that, we're a few minutes over. Thank you all for attending today. I think today was a very informative session, very productive, and I think we covered quite a lot of ground in a little bit of time. I encourage anyone in this group to please reach out to other members of this group if you ever have any kind of questions, or if something that we discussed today caught your interest, but maybe we didn't have time to cover it in as much detail as you wanted. I think that one of the main purposes of this group is really to facilitate a network, and that's the kind of thing that really working with somebody else or directly contacting somebody, I think, is a great way to facilitate that. So with this, to be respectful for everyone's time, thank you again, and looking forward to speaking with you all at the next meeting.